Hello, everyone. Welcome to our second coffee time session with Robin Appleby. I'm Ismail Ibrahim. Today, I have three of my colleagues from the Business Law Group: Nathan Holloway.
Hey, Ishmael.
Charlie Kim.
Hey, Ishmael.
And Jonathan Sepp.
Hey, Ismail.
Our topic today is on shareholder provisions to be aware of during the COVID pandemic. We're all aware of various operational challenges that businesses are facing today. What we think is not being discussed enough is the impact of the crisis on shareholders at the shareholder level. This crisis has created opportunities for some and challenges for others. Given this, for those individuals that are subject to shareholder agreements, it may be time to dust off your agreements and be better prepared for the road ahead. My first question is for Nathan. What are some of the provisions in shareholders' agreements that we should all be aware of during economic downturns or at times when the company and or the shareholder is facing cash sensitivities?
Thanks, Ishmael. So I'll start by saying that there's potentially a variety of different provisions that shareholders should be aware of, and every shareholder I would encourage to review and understand your particular agreement to see what rights are afforded to you and also the rights that are afforded to others in that agreement. However, generally speaking, the provisions that shareholders should expect to see will fall into three general categories. So first, there are exit mechanisms, which, as the name implies, deal with shareholders leaving the business, whether it's voluntarily, involuntarily, as a result of the relationship souring, or because they just generally want to exit the business venture. So one common mechanism is a shotgun clause, which provides a right to force other shareholders to buy shares or force other shareholders to sell their shares. So the process starts with the shareholder making a simultaneous offer to buy and offer to sell on the same terms to the other shareholders, who then have the right to respond by either accepting the offer to buy or accepting the offer to sell. And then another exit mechanism is a put and call option. So a put option is a right but not obligation of a shareholder to sell on the occurrence of a specific event, and then the call option is a right but not an obligation of shareholders to cause other shareholders to sell on the occurrence of a specific event, such as a default under the agreement. The second category I'll call preemptive rights, which are rights that may be exercised by shareholders upon the occurrence of a specific event. So an anti-dilution clause is one example, which provides that when a corporation wishes to issue new shares from Treasury, they must first offer those shares to the existing shareholders who have the right to purchase them on a pro rata basis. Then there might also be a right of first refusal, which provides that where a shareholder receives a third-party offer to purchase their shares, they must turn around and offer to sell those shares to the existing shareholders on the same terms as that third-party offer. And only once the shareholders either reject to exercise their rights or they don't exercise their rights within the allotted time, then that third-party offer can be pursued. And then there are drag-along and tag-along rights, which provide that where a majority shareholder receives an offer to purchase the shares, they can either drag the other shareholders along and force them to participate as well, or the minority shareholders might have the tag-along right, which allows them to participate and have their shares purchased on the same terms as what were offered to the majority shareholder. And then finally, there are capital calls. So in some cases, a corporation may not want to raise funds through externally funded debt. So a shareholders agreement may provide a mechanism for the corporation to require shareholders to provide injections of capital through shareholder loans.
Thanks, Nathan. Charlie, what in particular about these rights may cause concern to some shareholders or create opportunities for others?
Right, so the current economic downturn may result in lower valuations for businesses and create liquidity issues for shareholders. Shareholders may have less diversified source of income, their spouses could have been laid off from work, or they could have limited assets to put up as collateral. Or it could be that they're simply risk averse and not willing to mortgage non-corporate assets to secure capital. The depressed valuation of business certainly doesn't help, that it could impact the shareholder's ability to take out a loan. But the opposite could be true for other shareholders. So really, depending on which side of the coin you're on, this situation could play to your advantage or to your disadvantage vis-a-vis the rights of other shareholders under the shareholders agreement. So for example, in normal circumstances where shareholders are in similar financial position, the exercise of the shotgun clause would typically result in a fair offer price, since the shareholder receiving the shotgun notice gets to decide whether she's going to be the buyer or the seller at the same offer price. So it keeps everyone honest in the sense that the offer price tends not to be overstated or understated. But with COVID-19 and the current economic situation, that may have had a varying financial impact on the shareholders and their ability to secure capital. And some shareholders may also be feeling more cash pressure than other shareholders. So the shareholders with now a greater financial position, could make a lowball offer, knowing that the other shareholders are either cash sensitive or just won't be able to secure the required capital to become the buyer. This could be more the case if the initiating shareholder is bullish on the future prospects of the business or generally the larger macroeconomic trends of what the economy will look like post COVID-19. The other example is where there is a strategic buyer looking to deploy capital in a time with much less competition in the market. The buyer may make an offer that's less than desirable, but a desperate enough shareholder may jump on that opportunity. And under normal circumstances where shareholders may not be facing liquidity issues, the other shareholders may have exercised their right of first refusal to match that third-party offer. And now the consequence of not being able to do that is that the shareholders could be stuck with a new business partner that, quite frankly, they're not keen on. Or even worse, if the offer is to purchase all of the issued and outstanding shares, and the shareholder receiving the third-party offer exercises the drag-along provision, that could force other shareholders to sell their shares, even if they have no interest in exiting the business. Shareholders may also be impacted by the business sensitivity to cash availability. The businesses may have cash in the bank but see issues in the pipeline and want to secure additional resources to get through this difficult time. Or business might also put in self-imposed restrictions against taking out additional bank debts to fund the shortfall. So instead, the business looks to the shareholders to address the funding concerns by way of a cash call. And although shareholders with greater financial position or access to capital may have no issues making the cash call, other shareholders may go into default. And that default in turn could result in a loss of voting rights as a shareholder or as a director for the shareholder's nominee under the shareholders agreement. Alternatively, the business may proceed with an equity raise. And under that scenario, if a shareholder is unable to exercise his preemptive right, then that shareholder's interest will become diluted.
Thanks, Charlie. Jonathan, are there similar concerns related to business valuations?
Hey, Ismail, a shareholders agreement will typically have either a formula or a method for determining the valuation of the corporation or shares. And there's four ways that are often found, within the shareholders agreement, and maybe one or more of them, which is a formula based on past performance, usually profit, or a formula based on future anticipated profit or cash flows. A schedule sometimes is put into a shareholders agreement with a predetermined value, which can be updated from time to time. And the last way would be by referring it to a third-party professional referee, like a chartered business valuator. Part of the problem is when determining valuation is you're always looking at performance. So how is the performance weighted? So for example, if you're weighting towards a pre-COVID-19, pre-crisis period, is the purchase price value too high because you're looking at a value before the crisis? If you're looking to the future, how do you look to a future when the future is uncertain? Will the COVID-19 crisis end and the economy will rebound quickly, or will it rebound over time? The other concern or issue to look at is how do government programs impact valuation? So we have one-time government programs that are dealing with the crisis. Now, do those programs get ignored because they're one-time programs, or do we accommodate for them because we know that governments are going to come to the table with programs during times of crisis? Also, quite clearly, the programs do have impacted the financial performance of the company, and therefore, perhaps they're properly included.
Jonathan, now that we've learned about some of these issues, what do you recommend as the possible next steps for businesses?
Look, as a drafting principle, the first thing you have to recognize is you can't draft for all scenarios. First of all, a shareholders agreement is about an agreement that's to occur or to last for a very long period of time. And it's impossible to know what scenarios are going to occur throughout that period of time. Predicting them is just not possible. But even if we could predict them, how practical would it be to have a shareholders agreement the size of a Tolstoy novel? So we need to be practical when we draft. And so do we draft for once in a generation events like the Great Depression, Black Monday, 9/11, COVID-19, when businesses are almost always operating through the normal business cycle? And the answer probably is that we really need to draft for the normal business cycle, because that's almost always when businesses and shareholders are operating. But, you know, we've thought of using how force majeure may be used in this context. So there's been a lot discussed during this crisis about force majeure clauses. A force majeure is a clause that allows you to suspend rights and obligations during a period of crisis. Those are typically used in contracts that are for performance during a period of time, whereas a shareholders agreement really isn't about performance, it's about a collection of rights. It's a collection of rights. And so how does a force majeure clause work within a shareholders agreement? So firstly, we need to understand what the force majeure clause is, that there's a limitation, because the question is when did the crisis occur and when does it end? So if we look at when the crisis started, well, you know, maybe in this case, it may be easy, maybe not. Maybe we say, okay, it started when we were all sequestered to our homes and all businesses needed to stop operating. But when does it end? Does it end when we go back to business, when businesses open, or does it end when the consequences of the current crisis end? And when do they end? And that, so force majeure is not necessarily a panacea. But one of the things that we may say is, let's use a force majeure clause in the COVID-19 case. And let's say, well, maybe in those cases, you suspend your preemptive rights. Or maybe the consequences, as Charlie had explained, of not being able to meet a cash call, the consequences of a default are suspended. The other thing that we may need to deal with is the issue of fairness. So when drafting, parties are usually guided by the idea that they should be acting fairly with each other. There may be advantages between the parties at the time that you draft, and you acknowledge those advantages and accommodate for them in the drafting. Now, of course, fairness and advantages will change over time, and that happens whether or not there's a crisis. But in a crisis, the dynamic could change very quickly and very acutely. And so therefore, dealing with fairness becomes an issue. And perhaps the force majeure clause adapted for this kind of scenario may help. Another idea may be that in order to allow people to participate fully, you accommodate some of the issues that occur in a crisis. So for example, if the issue is the access to capital, perhaps the purchase price gets paid over time. And therefore, the issue to capital will not be as germane to the rights of the parties.
Thanks, Jonathan and Charlie and Nathan, for all of your great insights. To recap, we've learned today is that individuals that are subject to shareholder agreements should be aware of certain provisions embedded in their agreements. These provisions may provide opportunities for some and challenges for others. Moreover, we've learned that with respect to drafting, what may be fair today may not be fair in the future. Thus, going forward, we should be adjusting provisions in our shareholder agreements ahead of time to address similar concerns that may rise in the future. We hope that you've enjoyed this coffee time session today, and we look forward to you joining us for our other sessions in the future. We also encourage you to access more of our resources on our website at robinsappleby.com. Thank you, everyone.
Thanks, Ishmael.
Stay safe.
Goodbye.